didn't. You know, I think it might be useful to talk a little bit to our viewers about, with our viewers a little bit about how we do what we do. And so let me start with you, Justice Lillehag. I'm a litigant at the Court of Appeals. I don't think justice has been done, and I'm really unhappy.
You're sure justice hasn't been done.
Yeah, in fact, I'm sure justice hasn't been done. I'm unhappy about it. And so I'm going to ask the Supreme Court to take a run at this case. And it's not one of those cases they have to take. So take our viewers through the process about what that might mean in terms of whether or not they're going to hear my complaint.
Well, on behalf of your client, you're going to file what's called a petition for review with the Minnesota Supreme Court. As I mentioned, we get somewhere around 800 of those every year. We sit down twice a month and figure out which cases to take. And your petition is going to be short. You're going to tell us in a few pages why the case is important, why the Court of Appeals got off track, why your case might be of statewide significance, or at least really important in some particular area of the law. And then we will, the seven of us will conference and we'll decide whether to take the case. And the rule is that if 3 of the 7 justices want to take the case, we take the case. So then it's put on the calendar. Then at that point, now that we've done our work to that point, it goes back to you. And you file briefs. Now, it's always a joke. Lawyers' briefs aren't really briefs. They often go on at some length. We, of course, like short, succinct, persuasive briefs.
Which we rarely get.
We're prepared we get a lot of long briefs, and you know what? I never like it when judges complain about having to read what the parties are saying. That's part of the job description. I knew that was going to happen when I made an application to be on the Minnesota Supreme Court, and by and large, I like it very much. So the appellant, that is the party appealing from the Court of Appeals, will file a brief. Then the respondent, which is the party defending the Court of Appeals decision, will file a brief. Then there will be a reply brief. And sometimes associations and other people decide we want to try to weigh in on the case, and they'll file what are called amicus curiae briefs. They're telling the court why the case is important and why it should come out one way or another. We read all that. Now, interestingly, we very seldom talk about the case at all before there's oral argument. The oral argument occurs either in the state capitol ceremonial courtroom, which soon will be shut down for renovation, or in the Minnesota Judicial Center courtroom. And the gavel comes down, knock, knock. Mm-hmm. We come in our black robes and sit down with the Chief Justice at the center, and then in order of seniority going outwards. And then the appellant, the party appealing, has a chance to make its arguments why the Court of Appeals should be overturned. Now, this is not a one-way communication. The justices are asking questions of the lawyer that's appearing and expecting good and concise answers. And so it turns into a dialogue, not just with the lawyer, but the justices are really talking among themselves by asking the questions, and we're identifying what's important to the other justices. And then the other side has its chance, then there's a chance for rebuttal, and then the gavel goes down again and we leave the courtroom. Then we go into conference. We go immediately after the oral argument to a conference room, and it's just the 7 justices. There are not law clerks, there's not staff, and that's the place where we deliberate about the case. And we'll take as long as necessary so that all the arguments are aired, the pros and the cons, the justice, the injustices are all discussed. Then we'll take a tentative vote. There will be a majority. As I mentioned, often it's unanimous. There will be 1 justice assigned to write a majority opinion, and then if there are dissenters, there will be 1 or more dissenting opinions that will be prepared. Now that, I'm probably going on a little too long, and maybe the process might seem a little bit too long, but the reason why it will take some time before those opinions are issued is because we're writing for the court, not just for today, not just for tomorrow or next month or next year. We're writing potentially for the next 100 years, because with the exception of very few cases that go to the U.S. Supreme Court, this is the last word on the law in the state of Minnesota. And, you know, coming from private practice, I felt that as a pretty heavy burden. When I was in private practice, I would sometimes cite cases from the 1860s because they were good law then and they're good law now. And I'd like to think that when we're writing an opinion that somebody in the year 2114 is going to be reading the opinion and say, well, I don't know if I agree with that Justice Lillehaug, but he sure said it clearly, and I understand where he and the court were coming from. That's the goal.
That is the goal, and another goal is also to make sure that the law is understandable and flows from a predictable set of principles. And you know, one of the things that I think is really important, and I think we achieve quite often, even with very complex legal issues, we recognize that the law the case belongs to the parties in it, and they are first and foremost affected by our decision. And one of my goals, and I know it is of my colleagues too, because we work so hard at writing our opinions in a manner that is clear, that's precise, and a goal that I have is that the party, the person who is affected by the decision, the person whose case it is, can understand our decision, can read it and understand it. Certainly, they will have a conversation with their lawyer about the opinion and what it means. But I think we, as a court, in working through the decision writing process, give each other good feedback about how we can explain the law in a way that is accessible to everyday Minnesotans. And I love that value about us. I love that. I love the collegial, careful, respectful way that we deliberate about a case. We don't always agree, but we certainly are not disagreeable in our deliberations and in our conference. And so the model that we have for decision making, I think, is one that is perfectly created, I think, for decisions being made in important and difficult cases. And that's one of the reasons why I feel so honored to be able to serve in this capacity and feel like the work that we're doing is work that Minnesotans deserve to have done carefully, precisely, and in a fair and just way.
And let me pick up on Justice Wright's point about the opinions being understandable. I think it was Benjamin Franklin who said, you know, if I'd had more time, I would have written a shorter letter. My goal, and I know it's the goal of the other justices, is not to try to go on at great length, but to write clearly and precisely, and we hope briefly. So that people can understand that.
Sometimes accomplished, sometimes not, right?
Yes, it's a goal.